Got a question on TikTok asking, my landlord only accepts checks and wants me to mail them to them at presumably a designated address. Is that okay? Hi, my name is Rob Wells. I'm the Landlord Boy on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, to answer this question, I'm assuming only California law applies, and the first thing that I'm going to check is Civil Code 1947.3. And under this scenario, basically, if the landlord is only accepting checks, for example, and I'll include personal checks, money orders, cashier's checks, we'll put them all in the same category. I don't see that violating Civil Code Section 1947.3 because under state law, it's only required that a landlord or their property manager, agent, whatsoever, the limitation is that they offer at least one form of payment that is neither cash nor electronic transfer. So if this questionnaire is asking, hey, does the landlord have to take cash? Absolutely not. They don't have, unless there's a local ordinance that applies to that. Theoretically, that landlord does not have to accept cash. Okay, do they have to accept electronic funds transfer? Not necessarily as well under state law. Now, your mileage is going to vary. That doesn't prevent a tenant from making like a reasonable accommodation request under federal and state law to ask the landlord to change their policy for a qualified, medical or disability reason. The tenant could articulate, some form of reason why they would need that change for that particular, for fair housing purposes. But under a lease agreement, no, a landlord doesn't have to accept cash. And in fact, the landlord can designate inside the lease, they're supposed to actually under Civil Code Section 1962, where they want payment to be delivered to. And if it's only a place where it can be mailed, the landlord can elect to do that. Now, on some of my other videos, we've talked about the consequences of Civil Code 1962 and Code of Civil Procedure 1161 Subdivision 2 if your mailing or address, if your address is only where tenant could deliver rent payments only by mail, there are some consequences. And that consequence is if the tenant can show proof of mailing, like a certificate of mailing or a certified mailing of the payment, within 3 business days, basically, then that payment is deemed received by the landlord conclusively as of the date of the proof of mailing. So if I mail it on Friday, the 1st, basically, and the landlord doesn't get the payment till the 7th of the month because their address doesn't allow for personal delivery, the landlord is going to be conclusively presumed to receive that payment, on the date of the postmark. Okay. As to the payment, as to the timing of it. So there are some disadvantages of just having only a mail address to send rent to, but a landlord can state that, hey, you can mail the payment to them at that address only. Okay, so I don't see anything wrong with that. Obviously, any local ordinance, you have to check your local ordinances if their local municipality governs, payments, forms of payment that hypothetically could be true. You have to check with those ordinances as well. So landlords, if you are facing a tenant situation, where your tenant's not paying rent or you have questions about this type of stuff, feel free to reach out. We might be able to help out if you're in the Northern California area. Folks, put your comments, questions down below. I'll try to answer them. And until next time, folks, I'll talk to you then. Thanks.